Hello and welcome to episode number 328 of the Armin Show podcast, where we have been rolling. We have momentum and we are learning more about people, behavior, science, economics, law, a variety of topics, which is good. When you combine them, that's interesting to me. It's like the complex systems that they study at Santa Fe Institute or wherever it is. On this episode, we have the author of a book combining law and human behavior. Interesting concept right here. The book is called The Behavioral Code: The Hidden Ways the Law Makes Us Better or Worse. Two authors. One we have here, Benjamin van Rooij and Adam Fine. Benjamin joins us on this episode. Benjamin, welcome to the show.
Thank you so much for having me, Armin.
I'm glad to have you on. Now, before we get, there's quite a few things I like. Automatically, when I saw the book at the beginning, by the way, Robert Sapolsky right there, I've interviewed him before and he was wonderful. And I never see him on books, so that was nice. I was like, he's back in business. That's cool. He is super duper. And behave makes sense. Behavioral code. There's a linkage there. One of my favorite books, actually. I did a lot of episodes just breaking down the chapters of that book.
It's wonderful. It's a wonderful book. And I love the chapter that he has on free will and the law. It's a great chapter that we use in teaching, actually.
Oh, that makes sense. Right. That would apply. That's a good one. I like linkages like that. Now, before we get into the content of the book, first I would want to check your co-author and then your background. So your co-author, how did you end up working with Adam Fine in the first place? How have you known of each other and why team up on this book?
Great. So Adam was a graduate student doing a PhD in psychology at University of California, Irvine, where I was teaching at the time at the law school. And we started to collaborate on projects where we were studying how people's so-called what we call rule orientation, whether their personality is more oriented towards rules, whether it affects their own compliance with rules. So that's how we started. I had already the idea of developing this book from my own background. I can say more about that. And for Adam coming into this, he's a developmental psychologist who studies juvenile crime. And his experiences has been that that there's so much empirical knowledge about why juveniles and young adults commit crime that don't really translate into the law, and that all of this knowledge gets lost. And he'd also seen that working in practice, also teaching in schools. He'd seen again and again that sort of the scientific knowledge is not used in practice. So we combined both of our backgrounds into what became this book.
That's cool. I do like the application of and presentation of science in the book, which shows up a lot. It's not just legally based, and that's a nice feature because I like a lot of science and logical background between people and behavior. Now, as far as your background, you are at Amsterdam. You are professor of law and society at the University of Amsterdam in the School of Law, and you used to be at the University of California, Irvine. Take me through your path.
Yes.
From the start to there and today.
So for me, this book started a long time ago in 2000. My background, I was trained in a bachelor and master's of both of law as well as of Chinese language and cultures. And I went to China in 2000 to study environmental law. And I wanted to understand how these rules made in Beijing worked out at the local level. So there I was, I understood Chinese, I understood law, but I didn't understand behavior. And the more I looked at what was happening, the more I saw that everything I'd learned in law school didn't play out the way I thought. So that led me on this long journey of first studying these issues in China and then increasingly elsewhere, to really seeing, look, the way we lawyers who make up the rules that guide behavior, we control the biggest behavioral systems, that we have. We lack this sort of training and understanding of human conduct and organizational conduct needed to make these systems work well. So I started to go deeper and deeper into the empirics of this, also started to do my own empirical analysis, got trained in anthropology, public administration, criminology, and psychology. And that ended up, sort of seeing, look, I need to tell this story, first of all, to my colleagues in law, but more important, to a broader audience, because in the end, law is not made in a vacuum. It's made based on everybody's political preferences. And I saw also interacting with a lot of different people in the US, in Europe, in China, that most people have sort of assumptions about how law gets to shape behavior that are not in line with what we know scientifically. And that ended up becoming this popular science book that Adam and I did.
Right. That's nice. I like popular science. It will travel to many people, many more than maybe the basic underpinnings behind it would get to, because people don't go to those things unless there's a bit more pep, we might say.
Exactly.
Cool. Now, the behavioral code, the hidden ways the law makes us better. It's mentioning the hidden ways, which means items that are not explicitly laid out. What is the law missing at its base level that underneath it is impacting people?
So let me first say what we do see. So if we compare it, I mean, as a cliche with an iceberg, I mean, the top we see is sort of the visible part, which is punishment and sort of the clear incentives of the law. So the book has 2 chapters on that. And it shows that punishment as well as tort and rewards, they don't really work as we expect them. The evidence that punishment actually reduces bad conduct is very thin. And for many instances, there is no evidence. And sometimes it makes behavior worse. And the same applies to tort liability, where we have no evidence that it actually reduces risk in many areas, such as medical malpractice or, for instance, traffic accidents. So that's the visible part. The invisible part, to get there, you have to understand sort of what these visible parts are like. They're very much focused on 3 things. One is they assume people make a rational choice that is individual, and that they have the ability to make that choice. So these 3 things we question in the book. First of all, a lot of our behavior, and many books have shown that, that's not new in our book, is not conscious, deliberative. So there's a lot of unconscious things happening that are automated. Second, a lot of behavior is social. We respond to others. We don't just do that individually. And third, and this is maybe the most surprising thing in the book, is we don't often have the capacity either to engage in good behavior or the opportunity to engage in bad behavior. So once you take those 3 lessons into account, you get other mechanisms. First of all, a lot of our behavior is shaped by non-amoral issues. So morality matters. So we show the ways in which we develop morals, the way they become aligned with rules or not, and the way that then shapes behavior. Second, social norms, the behavior of others shapes how we act. Third, whether we think the system is legitimate matters. So our sort of belief in the system, which has a lot to do, for instance, how the system treats us. So police misconduct breeds more crime. That's one of the things that science has shown again and again. Fourth, our ability to follow rules. Most people don't know most rules. You'd be surprised the amount of law people don't know, even if there's very basic rights that people have at the workplace. They don't know their rights, they underestimate them. Basic criminal law rules, and even experts don't know the law. So doctors don't know the intricate rules of doctor-patient privilege very well. And we see that school principals don't know education rules very well. And also people are not always able to do what the law asks. And finally, and this is the strongest part, I think, in the book, is there's many instances where we're unable to do bad things and break the law. And we can actually have interventions there. So a very simple example is there is very cheap technology that would disable your iPhone or your other phone, a Samsung phone, or whatever you have, your Android phone, from being operated from the driver's seat. So we could just mandate that sort of technology to be in every car. That would mean that you can't operate the phone in a very risky manner. It also would mean that you don't need law enforcement, you don't need surveillance, you don't need all these other, visible things that have not been working very well to prevent accidents. So we show these different mechanisms, both the visible ones and the invisible ones, and we look at both what we know, what we don't know, and also how we can use it, and also what the limits are. We don't believe in a quick fix. We don't believe there's any simple way to make everybody behave better and comply better. If that were the case, we would have probably written the new Bible, which we didn't.
It's true. I like when you were describing punishment in the punishment chapter, how you describe it's not completely understood the effects until you look at, okay, after effects. Are people committing the crime again? What is causing them to be deterred? And then specific versus general deterrence, different methods of keeping them from committing some sort of crime. I also like the tipping levels, where at a certain point, people just don't commit crimes because they know punishment will impact them, but below that level, they think it's not going to relate to me. How can the law better relate punishment to people's behavior, or is punishment the wrong category for this, or a necessary element?
No, I think it's a necessary element. So if there's no punishment, you have impunity. So anybody who's seen The Walking Dead or any show, I mean, set in frontier areas in the mid-19th century in the US, can see what a system looks like if you don't have any sort of rules that are not backed up by state sanctions. At some point, that leads to a different type of chaos. So I do think punishment is a necessary element. As Beccaria, who we discuss in the book, it's a necessary evil. So that's also how you have to treat it. So you have to treat punishment as something you only want to do if it's really necessary, if it can help to prevent bad behavior. And then you have to ask the question, how does punishment actually get to impact behavior? And what the book shows, once you read the whole book, is actually, because we get back to punishment in nearly every chapter, is that punishment has many different effects on behavior. If you count all of them, there's 18 discussed in the book. And of these, 10 are positive, meaning that if you punish, you get better behavior. And 8 are positive, 10 are negative. So on the positive side, one is it ends impunity. I said that already. I'll also discuss in the book, there's deterrence. So punishment can deter in 2 ways. One is it can make people who break the law not reoffend again because they didn't like being punished. So the experience of being punished makes you not want to reoffend. So that's specific deterrence. You can also scare other people off who might want to break the law. That's general deterrence. And the book shows, as you just discussed, that there's limited evidence of this, and that the most important thing is the certainty of the punishment. And if it's not certain enough, then it won't have an effect. But once you look at the whole scale of things, you see that there is also negative elements. For instance, if you punish more, you may create so-called criminogenic effects. If you lock people up in jail, they might learn more crime from other people in jail. It may also have exclusionary effects. Ex-offenders, when they get back into society, in the US, for instance, they can be legally discriminated when looking for jobs, when looking for housing, and when they're trying to get access to education. And we know from research, when you have less access to education, for instance, you're more likely to reoffend. So it's these things. So it's once you're thinking about punishment from a behavioral point of view, you have to ask, what does it do? And how can we make the positive effects stronger while preventing its negative effects? And the problem now in punishment is we sort of discuss this only in very simplistic terms, only about deterrence and maybe locking people away so that they don't reoffend. And we don't understand the full influences. B, a lot of our discussion about punishment isn't about prevention. It's sort of about a retribution. And I'm not against retribution. It's just that I prefer, if I have to choose, to prevent new victims from having to have retribution for victims that already exist. So I think the more important question is, how can we prevent crime rather than have revenge against existing crime? I think that's the political discussion we should be having, which Adam and I have been trying to have in op-ed pages. We did a piece on preventative justice, which is really about, look, nobody likes bad behavior. Nobody likes crime. I think everybody agrees on that. Maybe we don't agree what is crime, but I think the core thing is we want to prevent it. And if we want to prevent it, if we're serious about it, then we have to look at the science. And the science, unfortunately, shows that what we need to prevent crime is not the same as what we intuitively feel that we should be doing against in order to take revenge against crime of the past. And that's one of the problems that we discuss in the book.
Wonderful. Yes, prevention before something. It's almost like a dentist. Prevention before you have some huge tooth issue, and then you need to handle that.
100%. And that's also where we draw a comparison with medicine. So in medicine, we see there's preventative medicine now. And there's evidence-based practice. So in the conclusion of the book, we really think that law and justice and talking about justice should be much more about A, prevention, B, about evidence-based.
That's true. Now, one thing that came to mind is, would you say that the law is a little bit more heavily focused on those, let's say, smaller minority who commit crime than the general public? Is there a possible focus they could be putting on more people than those who commit crime regularly and become very focused on like the hammer and nail kind of concept?
Yeah, so that's a difficult question. There's so much law. So, I mean, the most visible law that an average person sees, of course, is criminal law, which is focused on certain types of crime. But in the introduction, we kind of show, if you just drive around in your car, and if you would see all the rules that apply to your car,
Yeah.
how many thousands of rules you would be seeing? And those were just the ones that we took from the California Vehicle Code that you may appreciate because you live in LA,
Yeah.
and you probably drive a car because you live in LA.
Yeah.
Just the amount of law that applies to just your car and you driving it. So a lot of the law actually is all around you all the time. And the interesting thing is most of that law, it doesn't even come to actually shape behavior or come alive because nobody knows it. I mean, nobody deals with it. So there's only a small set of law that actually comes to the surface. And of that, most of that comes to the surface when there's a dispute. And then we go to court or there's law enforcement. And that part of the law is what we're all talking about. And what our book is about all kinds of ways in which law, as we have it, is shaping our behavior in everyday situations. And we want that law, and a lot of that works quite well. I think for cars, your car starts every morning, and so far it hasn't killed you yet. So probably law is doing okay there, right? But we want the law to do better there. And for that, I don't think it's easy to say, oh, it should only focus on these folks and not on these folks. I think that's a question that's impossible to answer. Rather, I would say, let's say, which types of, I would turn it around, I would say, which types of behavior do we think is highest risk with the highest impact, for which law might make a difference and for which it hasn't? For those types of law, I would say, let's make a behavioral analysis like we argue in the book. Let's find out, A, what are the rules? B, what are the implementing mechanisms of the rules? And do they actually make sense and can we improve them? So we can do that for crime and violent crime, or we can also do that, let's say, for jaywalking, if that's something we care about, or for Me Too cases, or for doping in sports. And those are indeed political questions because they're questions about what do we think is bad and what do we think needs to be addressed. And that's not something we answer in the book. We leave that to others.
I like that data analysis comes into play a variety now because we have so much wonderful recording of everything that we can see, okay, what's the impact of this a month later, a year later, 5 years later? It's kind of like Sapolsky would say with like a decision 1 minute from now, an hour from now, and so on. Now, if we have that kind of material and we've applied it to punishment, what are a few examples where punishment didn't work out well that come up in your description?
So the most interesting cases that are discussed in the book and that we have good data on are capital punishment and the 3 strikes you're out sentence enhancement. So let's start with capital punishment. So obviously with any of these things, you have on the one hand the influence variable, which would be capital punishment, and the other hand you have the outcome, which would be crime. The hard thing is crime has many causes. So there's many different causes to crime. So there can be really the demographics, how many youth you have. The more people you have between the age of 16 and 23, the more crime and the more violent crime you're going to have, period. That's something we know very well. Socioeconomic conditions. If there's more poverty, you're going to have more crime, etc. So you sort of have to filter out those things. So simply having a comparison, let's say you have 2 states, one state has abolished capital punishment, the other hasn't, and then comparing the effects of the amount of crime in the state that abolished compared with the other state is not going to get you there. So we see that in the earlier studies of capital punishment, the quality of the analysis wasn't very good at filtering out those effects. We've become better and better at that. But if I look at the latest report from the National Research Council that sort of overlooks all the research we have and gives advice to government about it, they say that still, given the complexity of the causality here, we cannot come to a certain conclusion that capital punishment deters or not. So it's very frustrating. The frustrating thing is the state of science is that we have no evidence that capital punishment deters. And then we come in with our voice, we say, okay, what does that mean? So the National Research Council just leaves it at that. We say, well, it is quite something to find that there's no evidence. It does have a meaning. It means that you cannot make an argument that it does deter, neither can you make an argument that it doesn't. But of course, capital punishment comes with tremendous costs. And those costs are justified by the fact that it would deter. That's also legally under the 8th Amendment in the US. Under one of the tests you have to do, you have to show that it serves a valid penological goal. And one of those goals is deterrence. And the court in the 1970s has actually sort of made the argument when it reinstated capital punishment after it sort of put it on a moratorium in the early 70s, that it does deter. And it then cherry-picked through the evidence. I mean, focusing on one of the empirical studies and not on all. So sort of what we learned from that is for capital punishment, anybody who says that it deters is not backed up by evidence. So if the argument to do capital punishment is deterrence, that argument just doesn't have the evidence. So I think that's an important thing in any debates about this. Second is, we need to, and this is a really important part that's not in the book as much as something that I'm developing now with my research team in Amsterdam, is we really argue that judges for questions about human behavior, such as the Supreme Court dealing with questions of capital punishment under the 8th Amendment, need a proper process in how to deal with empirical evidence. They can't cherry pick. And we draw on systematic review procedures that exist in academia. Then we argue that these procedures should be applied to also in court. So if you have a question that's empirical about behavior, you need to follow a procedure where you, collect all the evidence. So if you look at systematic review, you need to follow a procedure where you search engines of academic databases where you get everything under a search, and then you have a procedure where you code it for relevance and you include everything in what you review. Be that your coding protocols are sound, and then you can sort of come to a conclusion. So that's a very strong thing. For 3 strikes, you're out. Similar story. Of all the studies we've reviewed, we found all of them but 2 concluded that that 3 strikes you're out did not deter. Several found that it actually created more crime. Only 2 studies that we reviewed found that it did deter. One of these studies found it only deterred for non-violent crimes. Well, that's not why we have 3 strikes you're out. And the other found that it wasn't cost effective compared to more policing. So that's sort of the story there. Again, we see, if you look at what the Supreme Court did, they cherry-picked in the Ewing case, they cherry-picked through the evidence. So they did cite a report by the Attorney General of California showing that it did deter, and they didn't, for instance, look at all the work that Frank Zimmering from Berkeley did, showing that that report from the Attorney General didn't look at the right time frame. So if you look at 3 strikes you're out and you look immediately after the 3 strikes you're out, you see that crime goes down. If you look at the longer time frame before, you see that crime was already on the decline earlier. So it's those types of details, if you don't go into those. And what we try to do in the book is to try to give a balanced view. We do show what are arguments against what we show. So some popular science books are really fun to read and easy. Ours is fun to read, but we do portray the science. We do really want to show if there's a different scientific fact out there, a different scientific opinion, we want to show it. If there's doubt in the science, we show it, even if it's uncomfortable.
That's one thing that actually pulls me toward content, which makes me, I think, in the minority, because when there is more of that, I am more pulled into the book, whereas when it's more of what the more common book is, I can't really get into it too much because it's a bit too much of like names and places and not enough of the concepts behind it. Now, one thing that comes to mind is you were just describing this. If a lot of laws from, let's say, 20, 30, 40, 50, 60 years ago didn't include as much data analysis or empirical studies, and then they use that law, it's pinned down and coded, and then later on it's used as precedent for some new item repeatedly and repeatedly. How does one, now that we have better data and we're looking at longer periods of time, how do you adjust what is now like hard coded into the law?
Yeah, and this is a core question. And this is what we in the end of the book talk about behavioral jurisprudence. And this is a sort of, I mean, just as behavioral economics came to question core tenets in economic thinking, what we're arguing, and this is not only our own work, but we see we're kind of drawing upon decades of work of others. Based on that work, we're arguing that the law needs a behavioral correction. It direly needs one, so maybe even more than economics. And the behavioral correction here is broader than the behavioral correction economics. So behavioral correction economics is about sort of the basic tenets of individual rational choice thinking. The correction here is much broader because law in of itself has just not bothered itself too much with thinking about human conduct and about behavior and about influencing behavior, even though the law itself serves as a very important behavioral mechanism. But law is very much something that comes out of tradition, where we build upon tradition, more tradition. So this is exactly as you say, it is codifying existing norms, and then it builds new norms based on precedent and furthers them. Of course, there's other kinds of law where we regulate and we try and change behavior outside of precedent. So in order to change that, you need several things. One is you need to train legal future lawyers in a different way. And even though there is more and more economists, sociologists, psychologists in law schools, we don't yet see sufficiently that they're training lawyers to think about changing behavior in the future. A lot of the knowledge is applied to making decisions on what the right rules should be, sort of normative decisions, or B, sort of understanding how conflicts and conflict resolution works better, which is sort of, I mean, it's responding to behavior in the past rather than changing behavior in the future. So we argue for a different curricula. And for instance, in Amsterdam, I'm teaching a compulsory first-year law course to 800 students on law and human behavior. And that's revolutionary. We're the only curriculum that made that compulsory, which they did even before I came back to Amsterdam. So I mean, it's my colleagues who developed that, it's not me. Second, in legal practice, you need to make behavioral arguments more central. And there is, I think, good grounds for that. So we see, for instance, in our study of the Eighth Amendment, we see that lawyers on defense side could make arguments, if they were better trained in the behavioral science, they could kind of show that the other side's empirics is cherry-picked. They could show that it doesn't really reflect the state of knowledge. They could also appeal decisions from judges on that basis. I'm not saying that's easy, also because a lot of justices are not trained in this. And we've seen that Roberts, Chief Justice Roberts, in an unrelated case on redistricting, where also complex data was introduced, called it socio-legal gobbledygook. And I think gobbledygook means the sounds of hoofs that a donkey makes, but I would have to look that up. Yeah. So there's a longer period to go. Third, there is a large practice called compliance and ethics management in corporate practice, where there's a lot of money to be made. And I see increasingly this practice has moved out of sort of making sort of checking the boxes systems that we also discuss in the book to real behavioral change. And I see a lot of these high-end corporate lawyers, and this is in the end what law schools are catering to. It's in the end also people who go into clerkships want to go into corporate practice. So that's where it's pulling a lot of other practitioners there. And in that practice, that's where we see the biggest growth in jobs. And I'm working with a lot of different international corporations with the behavioral units they now have. And there's lawyers there and social science. So there's a big incentive. There's money to be made. So I think all of this can come together to change.
Speaking of that, in the coming years, let's say this decade up until 2030, would you see it as a light refining of laws that we've already had to adjust them a little bit, or a huge adjustment based on what we are able to now understand? So like a huge change, like a divergence, or like a convergence of slight adjustment
Yeah.
over time?
So, of course, the biggest type of legal change comes through legislation. And for instance, in the US, we know how hard it is to make any legislation nowadays. So based on that, I would say it's not going to be a huge adjustment. I think it will grow gradually. I think the biggest insight probably to start with from the book is just simply starting with, do people know the law? So for instance, we now have well over 300,000 rules that are backed by criminal sanctions that apply to corporations in the US. Just imagine.
Only 300,000.
300,000. So imagine you're a CEO in a company and you have 30 lawyers. Then each of these lawyers has to memorize and understand 10,000 rules. And they have to be able to communicate them with you and your team to be able to be ensured that everybody in your organization, and maybe it's a big organization, 10,000 people, understands them and complies with them. So that we all know is impossible. So a first start would be to kind of say, which rules do we really need and which ones don't we need? Which ones should we focus on? So I think that's a start. And it's an interesting thing. I'm an admitted progressive, and progressives always often like more rules and more government. But I've come to see that, well, maybe there is something here on the conservative side. Maybe we do need to, in earnest, think about, okay, which rules actually make sense and which don't. So I think that may be something politically where we can have a discussion together. We might not agree, but we may agree on the amount of rules, that it doesn't make sense to have all these inactive dead rules that are under the water and never coming to the surface.
That immediately made me think of like a closet where you have way more clothes than you remember, going all the way to the back. And then if they haven't been organized in many years, you don't remember what you have, what you don't have, what you'd like to get rid of, what you'd want to wear. And then the clutter actually cuts away at your ability to really pick and choose what's most valuable for you at this time. Clutter is really
That's a nice metaphor. I mean, the funny thing about law is, because we have this sort of ex post understanding. So think about the same company again, I just said. If they break a single rule, even if they're not aware of that rule, once they've broken the rule and somehow they get found out and somehow a prosecutor takes them to court, then we get all these lawyers involved. They find the right rule, they find all the case law, and ex post, it's not a problem that we don't know the law. It's only ex ante, once we want to shape future conduct, it's a problem. And that's sort of the problem we have in all of this. Most of us, and especially people in law, think too much ex post, think too much in terms of, okay, once we have a certain conduct, then we can find the applicable rules. But once we think about we want to prevent bad behavior, then that rule has to be there actively, or at least operationalized in a process that shapes behavior on an everyday basis.
Mm-hmm. One thing that just came to my mind is, in this category, what is one challenge you have had in recent time or currently in behavior with law? And then what's one thing that has been working well currently or in recent time that you'll be continuing?
Yeah, so one of the core challenges my research now focuses on is organizational culture. So if you think of some of the biggest scandals of the last year or 2 years, whether it's police misconduct, it is not just the individual police officer, it's very often the culture in the department or broader in the police force. If you think of Me Too cases, it's not always the predatory individual, it's often the enabling environment that's enabling it. If you look at the Weinstein case, you do see that a much broader environment in Hollywood was actually supporting that. If you think of Volkswagen and Dieselgate, if you think about Wells Fargo and what happened there, all cases of organizational culture. So what I'm doing now is developing a research project where we try and understand how we can better diagnose risk of a toxic organizational culture to develop, because once it has developed, it's very hard to change. So we're building case studies where we're looking at the worst cases, And we're trying to understand, okay, what patterns do we see here? What do we actually see that is of a risk that we can then discuss with other organizations at a much earlier phase where we can find out, look, maybe you should be aware that this may be a problem down the line and we can prevent it. So this is a big challenge. It's one that I've seen the DOJ, Department of Justice, a lot of major Wall Street organizations have all focused on, major banks, but nobody has really cracked this one yet because it's so complex. Where things are going well, I have to say I'm always more of a hopeless optimist in a sense that when I'm positive, I still see all the dark sides. I think several things that have worked well. So the book, for instance, we discussed seatbelts. So if you go back to early 1980s, every car in the US had a seatbelt because it was mandated by law, but nobody was wearing them. Seatbelt usage was only 15%. And we see that a combination of factors, states developing individual seatbelt mandates. We see some law enforcement, which did work there, the click it or ticket campaigns. There's still signs in California that I've seen, even though they're very low fines, only $100. We see these commercials, crash test dummy commercials, trying to convince people. And then we get the warning beeps, which sort of make it hard or uncomfortable to not wear seatbelts. And now it's become automated. So here we have a legal success where we have a legal rule that's gone all the way from, let's say, external incentives to social, we see other, to in the end, automated, unconscious behavior where we don't make a choice anymore. So this is the sort of success we want. We've seen a similar success, for instance, with smoking at work. Most people don't smoke at work anymore or at the workplace. Again, legal rule, changed it. We see similar success in the paper industry that cleaned up in the 70s and 80s because of law. And that's sort of what the book also does. It kind of tries to look at these successes and compare them where we failed. So we wear seatbelts, but we still speed on the 405, for instance, in LA. Everybody's speeding. We've stopped smoking at work, but somehow it's been impossible to get people not to drink during the 1920s and 30s, or any attempt at illicit drugs has failed and only created the opioid crisis. And the same for companies. We've dealt with water pollution, but somehow other pollution issues we've not been able to deal with. And it's those questions that are at the core of the book and why the title is The Hidden Ways the Law Makes It Better or Worse. It works or it doesn't.
I very much like that seatbelt example because when I was reading that, I was thinking, this is great. Before that, people are just driving, and if somebody told you wear your seatbelt, you're like, okay. But to turn it from that to automatically buckling in is a huge mental shift across the country. So I like that you brought the example there.
I mean, one interesting thing to mention there, I noticed a couple of years ago in China, and my wife, who just came back from South Sudan, that there's something different going on with seatbelts in some countries. In both countries, the driver actually has clicked in the seatbelt behind their back, so they're sitting in front of it, to stop the warning beeps. And if they get stopped, they quickly put it around them. So they actually make a very conscious decision not to wear it, which I find fascinating. I mean, and one answer I found in China, at least, is that the drivers in taxis, they don't use their air conditioning because it's more expensive. And it gets so hot, they don't find the seatbelt to be very comfortable.
It's these layers that are not added in with the usual law. That's just the main law. There's like little elements of, you didn't understand we have tornadoes, so I'm cautious. So I drive this way on this off-ramp or something.
Exactly.
That's fine. Now, one thing I want to go back to, because this is a larger point that I relate with philosophically, is the prevention value for any category, because once something is entrenched, it is super difficult to change it, kind of like the tooth example with some sort of cavity, or like the freeway system in Los Angeles once it's already set up. So that's why I very much connect with what you're representing of adjusting it beforehand, because once it's built in, you have to use the force of 1,000 Earths to change something that's already situated. How would you speak on that?
Yeah, so here the law and the legal field is more problematic than humanity general. So I think, so if I compare that with medicine, of course, medicine had a tradition of sort of dealing with symptoms, and for a very long time with very limited knowledge. And of course, there were other types of healing and healing knowledge and non-Western medicine that dealt with prevention much more than Western medicine ended up doing. But I think in law, we're so much focused on the spectacle, as I call it, the theater of the court. I mean, we sort of, if I say law, people are like, oh yeah, these people with robes, and we have the jury and the witnesses. And once you see, and that's also why we start the book with somebody driving in their car and then seeing all the rules, law is everywhere.
Right.
Law is everywhere. And that spectacle is sort of where law fails. If law fails, you end up in court. That's where law goes completely wrong, where we have the bad behavior and we need to assign liability and do all these arcane things that law does. But once we see the power of law in shaping everyday human conduct through rules and all the systems it can, it has to become about prevention. But then we come against this sort of tradition in legal thinking, which is all ex post. Much of it is ex post. It's the whole training. It's reading court cases. It's thinking from singular cases, not thinking about policy. If you study law, whether it's in the US or in Europe, and there's different types of training, you're studying law through major court cases. And sometimes a cool law professor will say, well, you know, the policy question, and they'll ask what the case means broader. But it's always a side question. And of course, the lawyer is not trained in answering causal questions about the future. You need econometrics, or you need psychology, or you need other types of disciplinary knowledge for that. You need to have data analytics and data science. I think we now fortunately live in a time where this much more is integrating, where we can get it together. But I think it only starts once we start taking the preventative question serious, and we need to do so in the field of law. I think second, in politics and in general public, we're less focused on the past, but we still are quite a lot. So if something goes wrong, any case where we are angry about something, whether it's progressives that are angry maybe with the latest Me Too scandal or with the latest police misconduct, or conservatives that may be angry with a violent crime or something else, we sort of extrapolate from the singular case, and then we want a law or a reaction in law on the singular case without asking what it means for the broader set of potential cases. So it means we're very reactive, and that is well-meaning, but it may not work very well for the future. And behavioral economics and some social psychologists like Tversky have shown already in earlier research that this sort of case-based bias, this sort of heuristic, this shortcut towards from the individual to extrapolate from the individual to the general is very harmful. And we're trying to bring that into law.
A lot of things came through my mind there. It's nice to relate the, let's say, law when it's directly some crime just happened, or surgery of a person right now, or auto repair of a car that's currently broken. But with data science, we can take these brief moments and then think about where they are on the bigger picture of ups and downs of happenings of people or their car or their health. Yeah. And then it gives like a more of an extended view versus Jones versus Johnson from 1986.
Exactly. And here you do get a really big pushback from law for right reason, maybe. So most people in law would say, look, the social scientist should not become the judge. So they say, and this the so-called fact value debate. So they say that the judge should in the end make the normative, the value-based question, and do so based on the facts. But in the end, it's the judge. So they're very scared that once you let the data analytics in, that it will crowd out the judge. This is also, I think, what Chief Justice Roberts tried to say in the redistricting case when he talked about sociological gobbledygook. He said, in it, I don't understand what is said here. He said, I can't judge that. And that's sort of where we are. And I make the opposite argument. I say, look, fine if they make the value judgment, but it should be based on the facts. And it should be based on a proper understanding of facts. So we need the facts to be there, which means you need to understand the facts in complexity. That means that if you're going to make a judgment, which is about also the future, which in many of these cases it may be, for instance, does capital management deter? You need to get the facts right. And that is going back to what I said earlier, introduce procedures that the evidence comes in the right way and is translated in the right way. But it may well be that in the future, this is not enough. It may well be that in the future, if we really care about prevention, we may have to rethink of what the role of a judge is and also what the role of the expertise of a judge should be.
layers of perspective. What would you say is the biggest difference between law today and law 40 years ago as far as learning it? Is there a huge difference in learning it at this time versus
Uh, yeah, I think there have been differences. So there's several. I think we have a much more interdisciplinary perspective of law. So law and economics in many law schools in the US became very dominant. So that means that at least there's sort of cost benefit analysis introduced into the classroom, introduced into saying, okay, is it actually good or bad that a law is the way it is? Not just based on philosophy, which is where it was, or based on other cases, but also based on cost benefit analysis. I think that's really strong. We see some of the legal psychology also becoming of influence, for instance, on testimony in criminal justice, on eyewitnesses, on memory, on expert practices. We also see that some of the critical scholarship has become more important. We see much more questioning of issues of race, discrimination, also bring data in there. And also power differentials. So a lot of the law and society studies have had some impact there. So I think that it has changed in that way. We're asking for the next level of change, which is to much more look at the preventative aspects. I think there's been some move there, but not enough.
in this category? Who are other individuals you have resonated with, or who you value their thoughts as like a base model in some form? Are there any people that come to mind, researchers or professors?
Oh yeah, there's too many to mention. So let me mention just a couple. One is Cass Sunstein. And I think his work, it's not just the book Nudge, which obviously had a big impact on practice, but I think his earlier work, I mean, he has done so much, but I mean, to mention some of the things, his kind of work about the availability heuristic and the cascade effect. So how we respond to a singular issue and we extrapolate that as a big problem that we need to regulate. So I think he's shown a lot about human cognition and how that plays a role. So he's, I think, one of the forces that has made behavioral law and economics more central in law. And of course, his role also being the regulatory czar under Obama, and I think he also plays a role now in the Biden administration. So I think his work is really influential. I think another line of work that has been influential is the behavioral ethics work. And we can think of people like Anton Brunzel and also Max Baserman. That work has been translated, its meaning for law, by Yuval Feldman, which I think is also an important way of thinking. And they show that our lack of cognition, or sorry, it's not a lack of cognition, that we don't just have a sort of non-deliberative cognition that goes against our own interests, but also makes it impossible for us to make ethical judgments. So we have a bounded ethicality, and they show how that then plays a role in law. I think finally to mention Sapolsky, we mentioned already, his book Behave, I think just getting really, I mean, for me, reading that whole book, and I'm happy that you unpacked, it's a book that you need to unpack.
Right.
You need to slow read it, which I love.
That was like 4 episodes.
Great. So what he did in his book, I think, really shows clearly the different ways in which once you take it serious, that we don't fully have this sort of free will, this sort of model of thinking of the human in the legal system that we need to grapple with. And it's not easy to grapple with it. And he has a very funny chapter about that, which with very serious implications. So I think that would be another side to this. But there's too many others to mention. I think Susan Silby's work, she's at MIT, massive important work on sort of the organizational side of this and the sociological side of how humans actually interact in shaping compliance and shaping what the rules mean and how they become to play a role in practice. There's just too many people to mention for me here. John Braithwaite has been vital as well.
Wonderful selection there. I like that you mentioned that there's a bigger picture concept. Sapolsky wrote that book and then he added that chapter in. If you don't add in all the elements, the loss is huge, because let's say he had written the whole book and left out that chapter, maybe the book would still be functional. But when he wrote that, that's highly valuable to an individual, maybe in law, and maybe a whole chapter of people's efforts can base off of that. So it's key to never leave items out. Variety, I like the concept of variety and adding in all the elements. That's cool.
Well, that's not what your publisher will advise you. So I think for Sapolsky, because of his earlier book, Why Zebras Don't Get Ulcers, great title, he may have been able to write the book in a way that he did. And what I love about that chapter is you can actually sort of read it as a standalone, which is brilliant because the book is so nuanced and complex, but you can sort of read it as a standalone.
I'm going to be looking back at that chapter. Also, you mentioned that title,
It's very funny. I mean, the way he starts, it's really good.
I took notes on the whole book, but I have to. And then the title, Why Zebras Don't Have Ulcers, reminds me the value of that kind of title. One time I spoke with an economist. Her book is An Economist Walks into a Brothel. These kinds of titles, they just, Alison Schrager, they really punch in, and then you're like, wait a minute, what happened there? That's a good point. My last question to you for this time would be, if you had a message to all people on the planet that you would want them to take away from your book, what would that be?
Yeah, if I would make it really short, I would say law matters. Make sure that the law works better for you. And what I mean with that is law keeps you safe from harm. Try and find out how it does and how you vote, your voting behavior, your behavior as a citizen, the way you talk about your preference for laws, how you can actually make sure that it works better for you. So in any preference you have, whether it's about preventing crime, preventing misconduct at work, making sure that you're safe on the road, make sure that once you make those decisions, you don't just follow your gut feelings of, oh, I really think it's a cool law. Rather really think about what would actually help to prevent bad behavior. And with COVID, the book also discusses that, we've all sort of become behavioral experts. We all have been targeted to do things we've never wanted to do in our whole lives. And we've all complied with the rules and broken them. So we all intuitively, and we also study this now, know what works and doesn't work for that issue. Try and look at that back and think about the next time that any law is discussed, to think about, okay, will it actually work to do the things I want it to do?
How does this law connect with me? Benjamin, I would like to thank you for having been on this episode discussing this book right here, The Behavioral Code, with your co-author, Adam Fine, and bringing us a variety of knowledge, connecting with past books as well, and guiding us into the law and how it connects with behavior.
Well, thank you so much for having me, Armin. That was great.
Wonderful. And we are out.